Oh. Okay. All right. Good afternoon. Sorry, we're reconvening a little later than I thought. It is 1:50, and we're going to proceed with comments. I think we're going to try and run through the comments. Sometimes we'll have clarifying questions, but I do want folks to get a chance to put it all on deck for our consideration and helping us figure out what we should do here. And hearing about people's concerns is incredibly important to us in figuring out what to do. All right. As I stated before the break, we have Robert Melhoff first from the Nagley Burke Irrigation District, and he'll be followed by Tim O'Laughlin.
Good afternoon. My name is Robert Melhoff. I'm the District Secretary and General Counsel for the Nagley Burke Irrigation District located just north of Tracy. Our lands are basically all riparian, and about 60% of it, more or less, it also has an overlapping pre-1914 appropriative right based on posting and recordation in September of 1912. My concerns are basically concern due process and a potential for a liability being incurred for taking or damaging of riparian property rights if the process that is currently being proposed is followed. Before I get into that, however, let me just say I'm speaking in opposition to the proposed regulations. I would also like to, I didn't put it in my written comments, but we would like to urge you not to adopt the exemptions in 878.1. With respect to the due process rights, if I may, you know, I've been listening to the comments and the presentations of staff, and I just have one observation. Due process doesn't mean you shoot the person and then give them a trial. And that, unfortunately, is what curtailment at the very beginning of the process with reconsideration does. It has real effects on the landowners in our particular district. If we get a curtailment notice, we're not going to be able to finish irrigating our crops. We're going to have substantial crop losses and potentially permanent diminution in value of lands if they go fallow for long periods of time or if orchards are lost. So it's extremely important to our constituent landowners that due process be followed. Your current regime of regulations does that by having a prior hearing, prior fact-finding, and then your various either enforcement, you know, procedures or fines. This process does not allow for that. You know, I facetiously gave you a criminal example, although it's not really that facetious. Let me suggest something to you, and that is this. If we receive, as riparians, the notice of curtailment with the required response telling us how much water you've used, you've already at least made some sort of preliminary determination by that notice of curtailment that we're not entitled to any of the water either in the river or in the delta. By requiring us then to respond and say, how much are you diverting, you're essentially asking us to incriminate ourselves because there is a criminal penalty as well as the $500 involved in your regulations. It's a misdemeanor, as I read the regulations. So, you know, you're basically, I'm suggesting to you that you're not going to get the type of response you want to get for the purposes of administering the procedures that you want to administer.
Can I ask you a quick
Sure.
question as your time is up? And I'm going to be tougher on time just because I want the folks, this pile of cards, to get through it. Do you feel the same way about it for the post-14s who, if they don't respond to curtailments, it's your more senior water that's at risk?
Well,
That's what I'm trying to
I
understand.
represent post-14 districts as well. We responded, we curtailed because we had to. It was a condition of our permit. Okay? So there are a different strata of water rights, and I'm here representing the most senior, if I will. And this is going to affect a violation of the takings clause of the California Constitution if you don't have a prior hearing to determine whether or not our rights are taken. Otherwise, your staff had better be absolutely certain that there is no riparian flow to which we are entitled.
Right, right. Yeah, I think the intention, what Mr. Howard was talking about, is we're not proposing to curtail everybody all at once. It's the tool that would be used when we were able to make the determination that there wasn't water for
Yep.
someone more junior to a senior in a given place.
But-
That's the proposal.
But the fault in the system is the curtailment a priori, ahead of everything else. I understand that you want to do it. I understand you want to do it for administrative convenience. I understand it has some real teeth in it, but you're also, I think, violating the Constitution when you do so.
Yeah, that might be. I'll turn to Mr. Luffer. Is there anything you want to clarify for folks who are listening? I know we can't do this with each time, but I do think there are a lot of people listening and a number of assertions made. I'm sorry, Mr. O'Loughlin, I didn't get to you before lunch. I apologize.
So obviously, when the Water Board is going about undertaking an enforcement action or determining water rights in certain proceedings, we are accustomed to a full evidentiary proceeding, and there is a process we are accustomed to. But due process is not, and you know, I will, to a certain extent, perhaps fault some of our presentations this morning, but I also think that there's some mischaracterizations among the commenters today. It is not black and white. It is a flexible doctrine, and the Supreme Court has put forward a multi-factor balancing test. You know, what the board's staff has put forward today for consideration is a flexible regulatory framework that would allow subsequent curtailment orders based on the evidence that's available at that point in time, responding to an administrative need, which is recognizing the incredible drought circumstance we have in California, the lack of availability of water, and expediting that process, but including due process checks after the fact to allow for petitions for reconsideration. These are not, and in many respects, these are not determining and quantifying water rights. In many respects, this exercise that would follow from the regulation is an exercise in water availability. It's a different character. We recognize that it does have an impact on a right, a significant right that people have relied upon. However, it is a balancing of multiple factors, and the risk of error and the availability for error correction through a petition for reconsideration, we believe, falls squarely within the Matthews v. Eldridge balancing.
If I might just respond, the impact occurs when the curtailment occurs. That's when the damage occurs to the riparian. I don't care what your process is after that. That's when the taking and the damaging occurs under Article 1, Section 19A.
Right. I suspect we'll come back to that. I suspect there'll be many arguments on all sides of that as the day wears on. Okay, thank you, Mr. Malhalf. Tim O'Loughlin, San Joaquin Tributaries Authority, followed by Harold Thomas. It is, but I was too far away from it. Thank you, Janine. Tim O'Loughlin, followed by Harold Thomas.
Thank you. First of all, I want to thank the board members for meeting with us over the last several months and discussing this issue with us. That's been very helpful, and we appreciate your time. Secondly, I'd like to thank Mr. O'Hagan of your staff for the work that he's done and his professionalism and responsiveness to our questions and facts and information things. I think the problem I had with your staff's presentation is going to come down to one thing. I think Les framed it very well today. Why are you doing this? Why are you doing this? And so when I started writing these comments down, and I heard DWR talk about illegal diversions in the Delta, I heard the Bureau talk about how they needed to protect their stored water. I heard your staff say that the overarching goal is to maintain salinity control in the Delta. I heard another, I think it was Diane, I may get this wrong, Diane, is to protect senior water supplies, i.e. storage. And so I started thinking about this more and more in the context of the settlement agreement or the settlement letter that we sent to you about the senior water right holders. So we were in a meeting last week with several of your board members and your Mr. Howard, and the request was made that to put our settlement agreement into play, we had to go to the SWP and CVP and get buy-off on it. And I thought that was kind of strange, and my clients thought that was kind of strange, because why, as the most senior water rights in the state, are we going to the most junior water rights for buy-off on a curtailment issue? And the response was, and actually I heard it again here this morning, was that stored water is a senior water right. Well, it's not.
It's not a water right, but it's protected because it was.
It
was diverted legally when it was diverted. They're not diverting now.
Absolutely. So now you've hit the nail on the head. This is so there's a disconnect between what you're trying to do and the goal that you're trying to achieve. And I think I have concurrence, and it'll be interesting to see what Mr. Birmingham says coming up behind me. And you heard it from Mr. Herrick. Stored water is being moved through the delta. Clearly, if you do not have a right to take stored water, okay, you're not even a legal user of that water. Right. That is not even a curtailment issue. That is a illegal diversion of water issue. You already have all the tools necessary to deal with this. Now, I'm not going to be mean about this, but as I actually agree with Mr. Herrick. This problem's been there since 1950. We've addressed it every time the water quality control plan comes up, that this issue needs to be addressed. And now in the middle of the drought, you're asking to resolve this issue. And so what we said previously to you in our statements to you in the staff is we don't understand this, because we're upstream. We're clearly not diverting the project's water. We're not. And even if we let our water go, we can't push more water back up into Shasta, Orville, or Folsom. Okay? So my statement to you is the problem in the Delta, if there is one, is, like Mr. Herrick said, bring those parties in front of this board, and you're going to have to do this eventually, and determine how water is going to move through the Delta, when they can divert, and under what conditions they can divert. Okay? And that's the issue, really. That's the issue that you're trying to address, and you're using the wrong methodology. So we would ask you to use your current enforcement actions, which you have at your disposal, and use them. So that problem, whether or not water continues to decline in the San Joaquin River Basin or the Sacramento River Basin, if you don't address that issue, that water's still going to be diverting in the Delta all through the summertime and into next year. So deal with it. And then that issue is, and I think everybody would support this, because we support that people should not take other people's water. Okay, that's I think everybody behind me would support that. We support senior water rights being protected. But it makes no sense to cut off a senior pre-14 right upstream in the San Joaquin River Basin for a junior right to divert stored water in the Delta. That doesn't make any sense. You're rewarding either Mr. Herrick's clients by pushing more water into the Delta so his clients have more water so he doesn't take as much Sacramento River water. Well, you're basically rewarding bad behavior. So don't do it. Take the enforcement action that you can take and do it. It's a mess. See, and the problem is, I'll just be blunt about this. No board and no state board has ever wanted to take this issue on. It's been punted on and punted on and punted on. And now at the time of the drought, it's manifested itself. Like we said earlier this year, some of these problems in the Delta would manifest themselves through this process. You know, some of them good, some of them bad, and this is one of them. So I would implore you to address the issue that way.
So I have some questions.
Go ahead. And then,
Well-
and then we'll have to close because there are a lot of
Okay,
other.
Yeah, I appreciate the way you've kind of framed the issue here. I think that really it's the elephant in the room, and that is it's the issue in the Delta. And I have asked staff this question, and which is why I posed it earlier today, and that is, are there other tools in the toolbox? And it sounds like you're identifying another tool. So my question to you and staff, we talked about the water availability analysis and the issue that most of us identified, and that is the need to have more transparency so that people kind of trust what it is we're doing. But would we need to go through wouldn't we need to still go through all of that with respect to a proceeding that you're talking about?
No, and actually not. In fact, see, this is the interesting thing about the question that's being posed and where you line up as a board from a policy perspective about what you're trying to achieve. If you're trying to protect stored water moving through the Delta for the projects, keep water up in storage in Shasta, Orville, and Folsom so they don't have to release additional water. It's not a water availability issue. It's a misappropriation of water issue by someone who's not even entitled to take that water. Because see, in water rights, the normal curtailment issue is water is in the river subject to two valid rights to take that water. Well, in this situation, you would curtail one or the other, and you'd say you're senior and you take that water before the other guy does. In the situation in which the assertion is that stored water is being diverted in the Delta, those people in the Delta have no right to that water.
Right.
They shouldn't be diverting it in the first place. Entirely different process, entirely different fact pattern, entirely different analysis. And it never gets to curtailment. Thank you.
Same impact. All right, save that one. Hi, Mr. Thomas.
Thank you.
And after that, series of David Guy, Andrew Hitchings, and Mark Van Camp from NACWA as a group.
Thank you very much. I represent 700 Forest Service cabins in the El Dorado National Forest on the American River. They're all junior rights holders. All of their water comes out of creeks or springs, and all of them who have registered, and that's not everybody, have curtailment notices now. We get regular communications from both the Forest Service and from members of my association saying, we've been curtailed, you've shut off our water, what are we going to do? Can we occupy our cabins this year? And so I'm asking that the health and safety exception or the domestic use exception be applied, because certainly all of our cabins are very small, 800 square feet, 1,000 square feet. These are seasonal, they're only occupied for 3 months of the year. And in fact, the contribution of these cabins to the water supply is minimal. We're the mice under the elephant in the room. It's just a small amount of water. That said, if the curtailment orders, and I want to be clear, if the curtailment order is adopted under the new regulations, are the 700 cabins to cease using water? I mean, are we going to be told to stop using water? Because we have you can't buy any water from a stream that's 10 miles downstream. So what happens? That's the question.
Are these seasonal, these are vacation cabins?
These are mostly vacation cabins. These are seasonal cabins, yes. And we're 700, but there's probably another 2,000 from San Bernardino to Mount Lassen that are all on Forest Service land. These are all Forest Service permitted cabins. In other words, one could argue that if there was a riparian right, we have the riparian rights that come to us via permit from the riparian user, but we all know that there is no reserved rights in national forests, so we would have to find a new legal basis for that wonderful theory. But that said, we're permittees of the national forest. We take our water from the streams. We take it for 3 months of the year, and we're all junior or unregistered. Thank you. Any help would be appreciated.
That's a hard one. Okay, NACWA, there are 3 of you. You asked for a little more time. If you can
We will be efficient.
do it in less, that would be better, because I know you can make the point well, and just think of your colleagues who are behind you. So
Yeah, thank you. No, we appreciate the
And-
opportunity. Good afternoon.
But let me just say, so the next person knows, in case they're in the other
Okay.
room. Gary, I believe it's Soyseth, if that's an I. Modesto Irrigation District is next.
Yeah, thank you. Good afternoon. I'm here today on behalf of Northern California Water Association, of course, representing the water right holders and the local governments in the Sacramento Valley, joined today by Andy Hitchings and Mark Van Camp, who are also going to be joining me in the presentation. It's a rough year out there. I think we all have seen that. I think it's helpful just to take a quick second and step back and think about April of this year, March of this year, when you all were working through some of the real difficult issues. And I don't think we should lose sight of the fact that you, the administration, working with the federal administration, developed an operations plan that is largely working pretty well. You adopted your temporary urgency change permit. You've issued post-14 curtailment notices. You've issued Term 91. And at least in our view, the Sacramento Valley, as a result of a lot of these institutional approaches and the work that has been done, a lot of that was hard, grinding work. The Valley has reached more or less an equilibrium, we believe, for this year. So as far as recommendations going forward, let me just plant two of those, and then Andy and Mark will support this in different ways. We believe that you're on solid footing when you talk about post-1914 water rights. We've been saying that, I think, in front of this board now for some time, and we believe that there's some more work that obviously can be done. It's hard work. Nobody underestimates that. But when you start getting into pre-1914 and riparian rights, it's a whole different world, and you've heard that from countless people today. It gets very tricky, very complicated, and is what we would love to do is pick up what I think board member Dodek started talking about is some intermediary steps. And what we would suggest, and what Mark Van Camp will elucidate a little bit more, is a process to bring some of the real knowledgeable stakeholders together here over the next several months to just try to work through the pre-14 riparian issues and try to find an approach, because the bottom line is if we don't get any rain going into next year, we all know that there has to be a process in place. Back in 1978, you issued curtailment notices in March, and I think we need to be prepared, or excuse me, in 77, you need to be prepared for that. And so I think as a group of interested stakeholders, we should commit to rolling up our sleeves, working with you and your staff to develop a process that can work for the pre-14 and riparians, and Mark will talk a little bit more about that. So if we could, we'll have Andy Hitchings first and then Mark Van Camp, and look forward to the discussion.
Hi.
Good afternoon, Chair Marcus, board members. Andy Hitchings for NACWA and other signatories to the comment letter. We submitted that on Friday, June 27th. I don't want to spend a lot of time summarizing that because the board has had that. We got it in early so that it was there for the board's and staff's digestion. We do want to start out by acknowledging the staff's efforts to depart from the approach that the board took with the Deer Creek regs. Some key changes that were made that resolved some key legal problems in our view of the Deer Creek regs were first, the curtailments that are proposed in this case are based solely on the availability of water. It's not based upon some blanket determination of unreasonableness, and we appreciate the moving away from that approach. Second, the health and safety exemption provisions under 878.1, they're not proposed as being applicable to curtailments under 875 in this case, and we appreciate that departure as well for all the reasons that we submitted in our comment letter on those prior regs. I do want to leave time for Mark Van Camp's presentation because I think he has a lot of information that the board and staff will be interested in. So I'm going to, instead of summarize the comments, just go to the two key policy issues that were listed in the staff's agenda item report for this. And first was, should the board adopt the proposed resolution? NACWA, as it mentioned in its comment letter, no, not as proposed. If it is going to be adopted, it should be limited to post-1914 water rights for many of the reasons that Mark is going to go through in his declaration or in his presentation. It should be limited to post-14 rights and should not include pre-14 or riparians. A couple key underpinnings for that position. First, and we've heard this earlier today, we're not hearing from senior water right holders that there's a need to do curtailments. There has been statements by the project operators, but not by senior water right holders, and the whole purpose of the regulation is to protect senior water rights. Second, the board shouldn't be rushing into an expansion of its jurisdiction extending to pre- and 1914 water rights when there have been so many technical issues raised in the comments that have been submitted and in the presentations earlier today. It's just going to lead to a lot of controversy, a lot of potential litigation. It's going to sap resources, and it goes back to the question, why do this now? Mark Van Camp's declaration and the presentation he submits is going to show there are significant uncertainties and a very low confidence level in the technical database that would be used as the underpinnings for the deputy director to issue curtailment orders. We heard some comments this morning that it's a crude tool, that it's misleading but telling, and that came from staff, and I think those should raise some pretty significant concerns. Like David said, I think it would be more reasonable and logical to try to iron out some of these problems through the remainder of this year. If we're still in this situation, then come March next year, if orders need to go out or notices need to go out, there'll be hopefully a sound technical basis for doing that.
Can I understand? So you're not just suggesting that we not cover pre-14 and riparians with the emergency curtailments. Are you arguing that we shouldn't touch pre-14s or riparians even if the numbers suggest there's not enough water for a more senior pre-14 or riparian?
No, you have a process for doing that. In fact, I think the board did that in 1977.
Right.
And so there, but we would
Okay, I
say
just wanted to be
stick to your
clear.
existing process for that.
Okay.
And then the second issue in the policy issues were, should proposed 875 be subject to the minimum health and safety exemption from curtailments and water rate seniority under 878.1? Our answer to that, as I indicated, is no. If the board is going to adopt the regulations, they should be amended as proposed to make sure that those exemptions do not apply to these curtailments. As we mentioned in our prior comment letters, but by reprioritizing and moving those exemptions ahead, we feel that violates the rule of priority and other provisions of law.
So what would you suggest those communities do? Sorry to put it to you, but you're the first one who's actually put it quite that clearly.
Well, we don't know what the scope of those communities are, whether there is going to be a need, and there are other mechanisms out there. The transfer market has been available. It's worked. It worked it's worked this year. It's worked in prior years, and we would suggest that that's the way to accomplish it.
Right. I think that is the right way in general, and I think what staff was talking about is trying to figure out how to narrowly constrain it for those circumstances where for whatever reason that water just isn't available. And then what would you have us do? Water trucks from OES, bottled water from somewhere? That's the question posed.
Yeah, and I
I just
don't
want you to
have
help me
an
think
answer
that through.
on that fact-specific circumstance, other than I think there are potentially other alternative water sources available. Without knowing the specific circumstances, I don't think the board should do a carve-out blanket for this just to cover that contingency, which we don't know to what extent it exists this year.
Right, and staff is trying to discern that. Okay,
Okay, thank
great.
you.
Thanks a lot. Mr. Van Camp?
Good afternoon, board members. My name is Mark Van Camp. I'm with MBK Engineers. I have 6 issues I want to raise, and I'll try to get through those in my allotted 3 minutes. First, division staff has done a lot of good work in trying to follow through the recommendations that are from the 1978 report by the division in an attempt to computerize their database.
Right.
But yet remains a lot of work to do to pursue curtailments of pre-14 and riparian water rights, while at the same time avoiding an adjudication of the system. Keep in mind, the statements of use were not, quote, required in the Delta or required without a fee or a penalty until 2009 or 2010. At that time, we eliminated the exception from the Delta, and required it by point of diversion, and it just needs a lot of work yet. And I'll explain that in more detail in a second. Second point, as shown on the map, which you have in your packet, is a map of the Sacramento Valley, an aerial photograph. I grabbed this from available public resources to show the Sacramento River settlement contractors, federal contractors, state settlement contractors along the Feather and some in the Delta, and private projects. Those are shown on that map to represent folks that have acquired a supplemental water in times of shortage. They're relying on stored water purchased from the projects or use of stored water from their own project. Another area not shown on this map but available to your staff would be those decreed areas that have a documented pre-14 water right or other. So I'm suggesting the State Board staff needs to use tools like this in their inspection process, and I heard that earlier, the prioritization of your inspections that I know are currently occurring. Third item, which was touched on earlier, is the recent operations of the projects. I just want to acknowledge their efforts this year. I took a look at what they submitted in April, and that's contained in my package. Their storage at the end of May was greater than what they estimated. They have, in my understanding, has met the water quality requirements, delta outflow pursuant to your temporary urgency change petition orders. And I believe as far as storage, a glance at it this morning, collectively, they've done that for June as well. Fourth item, division, the water right database. I have acquired the water right database, working with your staff, very cooperative. Unfortunately, it's been a very short time frame. I first acquired it, the database for use in this year in May, and then again, another subsequent database in June. So I haven't had a lot of time to dive into it, and I got to ask myself, well, how much can I charge my clients to be looking at the statewide database? So the post-14 water right database, it's pretty easy. You know, you got a system where you file the water rights, so the priority date is easily acquired. It still needs to be verified and checked with overlap of pre-14 and non-consumptive use filings. In fact, the May 1 database I had an application 5631, which you might recognize the number, which is a state filing for power use. And it had a use that would be a demand to calculate whether water is available this year of 350,000 acre feet of water. That doesn't give me great assurance that that database is at a level of use to go and curtail people. That was a post-14 water right. I believe some of those have been corrected, but I'm
Yeah,
just not
right.
sure.
They happen.
Pre-14 and riparians. Next chart, please. Very difficult to see on the screen. Keep in mind this has been developed over 5 years, roughly. The white line shows what's in the reporting database that your staff proposes to use as a, quote, demand for the system. I'm not against using those numbers for a demand as long as they're reasonable. The gray line shows what we find in your ERIMS database. So on that first one, if you were to, the first point on that first set of lines is that it's multiple uses, irrigation, hydropower, fish hatchery. So it's kind of difficult to see how much of that water is used for irrigation in that case. The next one is a riparian. I would point to you that in ERIMS, it says it's inactive. That has a requirement that's built into the demand for determining whether water rights are curtailed, and your ERIMS database says it's inactive. I can go through these. The next one is the fact that it's a significant quantity of water, over several hundred acre feet per acre. If I was to look at that, I know of no one that applies that amount of water for irrigation. The next one says it's pre-14. It has no priority date associated with it in the database. So I'm not certain how we can curtail pre-14s when we're not certain on the priority date. And last but not least, one without the gray line is simply a power filing that still is in the database. I know your staff is working hard to try to clean those up,
Right,
but they're not all done yet.
right. Can
So,
co-
speed up.
sum up, yeah.
Okay. Next graph, I did the calculation for the Sacramento River only system. This is similar to your Appendix 9. So looking at the Sacramento River, not considering the delta storage concept, which would provide more water to riparians in the North Delta. So you can see on this graph, I believe that based on the available Sac River supply from May of 2014, there's adequate water to meet riparian demands in the Sacramento River system Thus, there's some water available for pre-14, and your database is not in a position to really curtail in a known priority system. So my suggested actions is the next graph.
All right, and this will be your last
Yes,
graph?
2 slides,
It's
sorry.
Gone
Just
way
thorough.
longer than advertised. Oh.
I can leave these for you to read, and we can.
No, go ahead and say it. I'm just concerned about everyone else who's waiting.
You need to follow through on quality assurance on the database, those post-14 statements. You should verify that with your old
Mm-hmm.
1978 report. You should verify that with statewide planning models, which I heard first time today from Mr. Grober. I'm glad that's occurring. Expand the database so you can do it geographically.
Mm-hmm.
And then you need to pursue your enforcement, the next slide, on post-14 water rights. And I respect the board members' idea of doing it in a very strategic manner. I'll leave
Thank
you
you.
with that.
Great.
Thank you.
Thank you.
I have a question of staff, and if you could stay just a second, Mr. Van Camp. The last chart where you've got the graph, how were you able to put that together if the information that you got from the database doesn't seem to be accurate?
The graph that's not up, the data I used, the available flow is from DWR's Bulletin 120 for this year. The riparian demands I show on that from the Sacramento River side of things is from the 1978 report by your staff, which relied on a lot of good historical data that led to the Sac River settlement contracts, the development of the whole state and federal projects.
Okay, and it just very generally speaking, does staff's chart look different from that? Because I thought I saw, the last time I saw the chart, they were intersecting supply and demand.
What I presented today, and I think what we've shown, is the combined riparian and pre-14 demand. I'd have to check with Mr. O'Hagan to know if he has that or if he knows exactly comparing the SAC riparian demand and SAC supply. I don't have a quick answer. But I will say, while he's coming to the podium, this is the type of thing why we're still checking this information, why some of the comments made in terms of putting out the information we have so it can be validated might be a useful addition.
Right.
Okay.
John O'Hagan. The graph that we show on the website has 2 supply curves. I believe this one is showing the 50% Bulletin 120 supply curve. We also are using the 90% probability supply curve, and that would be lower, so I can't speak to whether that would intersect, but I believe our data
Right.
uses the 90% right now based on the worst-case scenario, and the daily track of our flows for the, I could speak to the San Joaquin, is below the 90 percentile right now. I can't speak to the 78 demand. I'm not sure if that includes the delta demand also from the Sacramento River.
So, if I may, I would
Briefly, just because I'm looking at a bunch of people waiting
it
their
would
turn.
be great to have the interaction with
Right.
staff and understanding that what they've done versus what I've done. And yes, it does include the North Delta Water Agency, which is referred to as the SAC Basin in your database.
Great.
Thank you. And
Thank
then that last slide that you had with the suggestions, can you, I don't know if it's in your comments for NACWA. Do we have it in the letter? Okay, thanks.
Yeah.
I believe we have it in the comments.
Right. Thank you. Gary Soiseth from Modesto Irrigation. My apologies if I mispronounced
No,
it.
you
And
did
then
well. Yeah.
Herb Smart from Turlock Irrigation District will be next.
Perfect. Thank you. Good afternoon. My name is Gary Soiseth, and I'm here representing the farmers, citizens, and ranchers of the Modesto Irrigation District. I appreciate the opportunity you've given us to comment on the board's consideration of a proposed resolution regarding emergency regulations for curtailment of diversions to protect senior water rights. As the most senior water right holder of the Tuolumne River, along with the Turlock Irrigation District in the city and county of San Francisco, MID has submitted formal comments, which I believe there's some technical difficulties. We submitted them on time, but I think they're in limbo somewhere, so I would urge staff, if you could work with us, we'd like to make sure you guys get those comments. They go into much more detail.
Okay.
Only be about 2 minutes. I'll take a moment to just highlight some of our general policy concerns. First, as Ms. Giordano mentioned earlier before the break, MID strongly believes that the board should invest its efforts to compel compliance with those curtailed post-1914 water right holders that have yet to respond to the board's existing curtailment orders before issuing new curtailment regulations or orders. It sounds like you're well aware of that. Second, it achieves little to deprive senior water right holders from taking their water if that water will then be illegally diverted by others downstream. This is not only viewed by us as contrary to common sense and a basic sense of fairness, but it's unlawful. These actions will not stop known illegal diverters who are certain to benefit after lawful water right holders stop diverting. Third, MID is concerned with the inconsistent application of orders. Specifically, there are no metrics identified by the board as of yet that will trigger the emergency curtailment, no identification as to whom it will be directed, and no rationale given for these actions. We believe consistency is in administering any regulations from the board will be key to our irrigation district's ability to provide critical water to the needs of our farms, our cities, and the local environment. Fourth, the proposed emergency regulations don't contemplate how or under what conditions the curtailment could end. Should the board adopt the proposed regulations, the board must also create clear procedures for senior water right holders to confidently divert water into storage during unpredictable and often short periods of rainfall. And finally, contrary to the board's hopes and best intentions, the proposed emergency regulations will not create any new water in the system. Put plainly, the inflows are or will be less than the outflows, which means all diverted water is being diverted out of storage, as was mentioned earlier. For well over a century, MID and its partners have planned for the needs not only of our San Joaquin Valley farmers, but also for the citizens of our cities and for the wildlife within our watersheds. Our irrigation district has been used time and time again as an example of proper water management on the local level, and it's our concern that the board intends to disrupt these long-standing, well-planned efforts with untested, somewhat ambiguous, and hastily proposed regulations. Our ability to provide our farms, cities, and local watersheds with water in this historic drought rests in our ability to actively and independently manage the very systems we efficiently operate each day. As MID and our fellow irrigation districts have proven through our cooperation with the board's post-1914 curtailment orders, we look forward to working with the board to find common sense and lawful solutions that help the San Joaquin Valley. Thank you.
Thank you. Excellent use of 3 minutes.
Yeah, definitely.
We'll get a little clip and show people how to do it.
Exactly.
Thank you. That was really good. No disrespect intended to anyone else. Herb Smart from Turlock Irrigation District, followed by Abe Hathaway.
Good afternoon, Chair Marcus and other members of the board. My name is Herb Smart, and I am proud to be here representing Turlock Irrigation District and its customers. I will refer you to TID's written comments on the proposed emergency regulations for additional detail, but now I'm going to try and be as brief as my predecessor and make a few brief points. For now, I'm going to make 3 general points on this topic by looking into one specific word. That word is the noun order. It has many meanings, but today I'm going to focus on 3. One definition of order refers to a succession or sequence. In this vein, TID is concerned of the State Water Board's intent to take action on these draft regulations before completing the process it has already set forth with post-1914 curtailment notices issued throughout May. TID received such a post-1914 curtailment notice and is part of the select few who chose to comply with the notice and complete the certification form. It's not unreasonable to ask that you see the existing process through before embarking on another, and that you investigate those water rights holders not in compliance before regulating those who are. Another definition of the word order refers to a command or mandate. Regardless of how the board acts on any final emergency regulation language, TID is concerned about the manner in which any emergency curtailment orders may be administered. Thus far, there's a level of confusion within the regulated community as to how you plan to consistently and lawfully parlay any final regulation into administrative orders, and perhaps even more importantly, as was discussed earlier today, how you plan to clearly and transparently communicate the process in which orders are issued. A final definition of order refers to a condition of harmonious arrangement. I point you to the Tuolumne River as an example of this level of order among water rights holders coping with the drought. as evidenced by the commonality of opinion shared by TID, Modesto Irrigation District, and the City and County of San Francisco on this matter. The same logic follows in a letter sent by several senior water right holders on the San Joaquin River system. The letter requested the board withhold taking any curtailment action until it receives a complaint from a valid senior water rights holder, because the signatories have already developed operation plans that do not require and would not benefit from the State Water Board taking curtailment action. To that effect, TID recommends that you do not adopt the regulations as proposed. In closing, TID thanks the board for its time and requests that the board consider our comments, as well as comments from the San Joaquin Tributaries Authority and its member agencies. Thank you again.
Thank you very much. Good. Very clear. Abe Hathaway, Hathaway Bernie Ranch, followed by Jonathan Knapp from the SFPUC.
Chair Marcus, board members, my name is Abe Hathaway, and I'd like to publicly acknowledge the cooperation I've had with the staff on the phone, helping me prepare for this presentation. I'm a general partner in Hathaway Bernie Ranch, a family ranch. We have a pre-1914 adjudicated water right from Bernie Creek to irrigate approximately 400 acres of certified organic irrigated pasture and cropland in the Bernie Basin in Shasta County. I'm here today for some clarification on where my adjudicated water rights are addressed in this proposal and in the finding of emergency. I am under the impression that this board may not even have the authority to regulate water rights initiated before 1914. And in my reading of the emergency findings, I find no mention of those rights except as an informational tool. My question is, where in the proposal do the pre-1914 adjudicated rights align with regard to riparian and appropriative rights when you're talking about protecting senior water rights? Now I can just continue. We don't have to worry about commingling and all the other problems because the water comes directly out of springs at the foot of Bernie Mountain, and our water flows north to Lake Britton and then flows south to end up in Los Angeles and all other points needed. Adjudicated water right holders have a decree issued by a Superior Court judge. They are court orders. Our water rights are contracted with DWR for the administration of those rights. So we have a water master that assures that the decrees are followed to the extent of the law that has been placed out. Bernie Creek, like most other tributaries to the Pitt and Sacramento River that have decrees, have the opportunity to use the water to the full extent of their decrees. The contemplation of changing this at this point will affect the contracts that we agreed to in January that were self-administered at 50% of the previous years because we had already recognized that the water availability to us had been greatly reduced. In the adjudicated process, the judge already has divided all the water in our creek. We get our decree allotment whether the creek is flowing at 100% or at 20%. And as I left the house this morning, Bernie Creek was flowing at 42%. In reality, we are already dealing with curtailments by nature.
Right.
I propose that you exclude adjudicated pre-1914 water rights from this proposal. There has not been enough understanding of how these rights align with the appropriated rights or the riparian rights. Our decree is actually enforced by the Shasta County Superior Court.
Mm-hmm.
In the emergency finding document on page 1, it states that the board can implement curtailment when water is not available under the diverter's priority of right, which does not happen in the situations that we're in. And when we address staff, they said, well, there may be a more senior water right holder downstream. That's our concern. How far downstream and who would be more senior than an adjudicated pre-1914 right? There are so few adjudicated rights actually in California that they have not been considered while writing most proposals and water findings. Mm-hmm. And we're talking about the adjudicated ones, not just all the pre-14 appropriate and, you know, the miners on the hillside washing gold that had appropriative rights. Like many that spoke before me, I object to that process where the due process will be removed and we'll receive a curtailment notice without any recourse except reconsideration after fines have already been levied. And
Can
my
I-
final question,
Okay.
to wrap
Like,
up,
quickly, because I want to get
I
somewhat
already
of an answer.
received a notice that says you may be curtailed, okay? Does that mean that I'm paying the $500 now?
No.
All right, thank you.
We did a, you don't have to move that quickly. Okay, I'm out of here. No, we actually went out of our way to we did a notice of a notice.
That's right.
In January, and then we've done notices, and then we'll do
We received
curtailments because
this
we're
one,
trying to raise the flag. But
May.
can someone answer the question? I know I've asked this before because others have asked it, but I can't remember the answer. When someone's in an adjudicated basin that has the provisions for this kind of crazy dry year, the answer, it sounds like you got is theoretically correct, but who can give him the correct? And maybe we're not going to get it all done right while we're sitting here. But
appreciate
if you
that.
can illuminate it for folks in that situation so we can figure that out.
Yeah, I can't address any particular adjudication, but certainly adjudications are something that we're going to have to take into account in doing the curtailments, because in most, if not all of them, they may not set priority dates, but they set relative priority. And if that's how the board has to implement curtailments on a specific adjudicated watershed, then that's the best available information for the priority date. Of course, we're considering relative priority, supply, and demand. And if it's simple, if there's a simply adjudicated watershed that has all of the rights laid out, we'll read it and apply it.
But if those are already being administered by the Department of Water Resource by contract, then those full rights are already being applied. Am I correct?
We'd have to
We
look
may
at
have
the
to contact the Department of Water Resources as to how they're releasing the water, but I think in general we'd probably assume that they are, if they're the ones managing the water, then most likely they are managing it correctly, absent us hearing otherwise. We're concerned about the appropriate diverter getting the water they're entitled to. So if we are dealing with adjudicated stream reaches that don't have other water users that are outside of the adjudication, and that complex issue, then I think we would probably assume at the first step that the Department of Water Resources is implementing the adjudication, and we don't have anything that we have to do further. But there also may be issues of somebody being upstream of the delta, and if we have post-14 and pre-14 water rights that are junior to downstream pre-14s, that would need to be taken into account. And I think that's one of the questions that he was raising, is who could be senior downstream, and that's going to depend on where you are in the state
But
and how
then
your watershed works.
Right, but then wouldn't you be talking to the water master about that whole bucket
We
of management as opposed to each individual? Which may be where the confusion is.
Maybe John O'Hagan can speak to this better than
I mean, don't give me, one of the main things I want, just because of course I'm looking at everybody waiting, and there may be people in the other room as well. Can you give your contact, John, can you just talk to him after this? That would be great.
Yes, thank you. And again, I
that'll
appreciate your staff's
They're trying.
diligence and patience with me. Thank you.
No, thank you. Okay, Jonathan Knapp from the SFPUC says you may split time with Daniel Steiner. If there's a way to not to keep moving, that would be terrific.
Yeah, we won't be doing that.
Okay, and then after that will be Matt Clifford from Trout Unlimited.
Okay, good afternoon, Chair Marcus, members of the board. My name is Jonathan Knapp. I'm an attorney with the San Francisco City Attorney's Office, and I'm here on behalf of the San Francisco Public Utilities Commission. We submitted written comments on Friday in which we identified a number of significant legal and practical issues with the emergency regulations as proposed by staff. I'd like to use my time today to just highlight one of those issues for your consideration. And I'll begin by saying that we object to the emergency regulations as opposed. We're opposed to the emergency regulations as proposed. But if the board goes ahead and adopts the emergency regulations over the objections of San Francisco and others, then San Francisco requests that any findings, orders, or decisions taken or made by the board to implement or enforce the regulations should be expressly designated as non-precedential. In accordance with Government Code Section 11425.60, the State Water Board designates decisions and orders as non-precedential whenever they are based on unique circumstances. The emergency regulations and any curtailment actions taken to implement the regulations are by definition unique circumstances occasioned by the unprecedented drought and should not be relied upon to establish new precedent regarding the State Water Board's non-emergency authority over pre-1914 appropriative and riparian water rights. Senior water right holders like San Francisco are also gravely concerned that curtailment orders issued under the emergency regulations could contain findings regarding the existence or extent of water rights, even though there may have been no meaningful opportunity to challenge the board's actions before curtailment orders are finalized. Like all water agencies, San Francisco must treat any threat to the lawful exercise of its water rights very seriously. If the board adopts the emergency regulations, San Francisco requests the board's express assurance that no new precedent will be established as a result of the adoption or implementation of the regulations. Thank you very much.
Thank you. Interesting. Matt Clifford, Trout Unlimited, followed by Barry Hill, U.S. Forest Service.
Good afternoon, Madam Chairman, members. My name is Matt Clifford. I'm speaking on behalf of Trout Unlimited, the nation's oldest and largest conservation organization dedicated to cold water fisheries. And I am here to speak in support of the proposed rule. The board here today, or this year, has a monumental task before it, as we see it, and that is to administer the use of water during the most severe drought in the state's history. And in a time when harms are rapidly unfolding throughout the system. And in light of that monumental task, when we look at this rule, we see a common sense approach that's consistent with common sense and with California water law, and is structured in a way that we think will, in a rational way, to protect senior water rights and public trust resources. And it's evident when we look at the rule, and I think based on what we've heard today, that a lot of thought has gone into this rule. The board is taking a very thoughtful approach, and the staff has really put a lot of thought into this, and we appreciate that at all and want to recognize that. I want to make a few quick comments about, and general comments about different parts of the rule in general. And I'll start off with, we think the board has the clear legal authority to do this. With regard to pre-14 rights and riparian rights, I think that any doubt that may have lingered about that was resolved recently with the appellate court decision in a light case upholding this board's regulation, the frost protection regulation, in which the court clearly stated that the board has the authority to ensure reasonable use and prevent waste by all water users, and not just those that are subject to the board's permitting authority. And I think that removes a lot of the uncertainty about with regard to the pre-14 and riparian rights. And I'll just note quickly that those doctrines are flexible doctrines. So what may be a reasonable use, perfectly in normal times, it may not be reasonable use in light of drought. With regard to the health